We built this city on rock and roll. Built this city. We built this city on rock and roll.
Good afternoon, Omaha. I'm Rhonda Burgundy, and you are now watching Channel 4 News at 2. Today's special broadcast is all about the Brown versus Board of Education case. But first, we must backtrack and look at the history and what brought us to this monumental moment in time.
The case was originally initiated by the members of the NAACP local chapter in Topeka, Kansas. 13 different parents volunteered to participate in the summer of 1950. They took their children to schools in their local neighborhoods and tried to enroll them for school the upcoming year. All were refused, and therefore parents filed a suit against the Topeka Board of Education on behalf of the 20 children. Oliver Brown, a minister and a parent, was the first listed on the suit, so the case took his name. Charles Bledsoe, Charles Scott, and John Scott, all local lawyers, were assisted by Robert Carter and Jack Greensburg, part of the NAACP Legal Defense and Education Fund, Inc. The case was officially filed on February 1951, and the U.S. District Court ruled against the plaintiffs.
And you, Britt Tamlin.
Due to the Brown versus Board of Education case, the U.S. made great strides towards opening the doors of education to all students. With court orders and active enforcement of civil rights laws, progress towards integrated schools continued throughout the late 1980s. A major part of this is the Little Rock Nine. It is a great monumental. The Brown versus Board of Education case can also be credited to leading to the Civil Rights Act of 1964, the Voting Rights Act of 1965, and the Civil Rights Movement in general. Due to the Brown versus Board of Education case, the U.S. changed its ways by this opened up the different strategies to learning and the use of new policies and procedures beneficial to all students. This gave a setting in which students of various ethnic backgrounds could meet and interact on their own. Chief of Justice Earl Warren in the Brown versus Board of Education case has turned the tide and has changed the direction forever on the role of race in this country.
And to you, Brianna Fantana.
The decision made in the Brown versus Board of Education case was a turning point in this country's history. The relationship between races would never be the same again because Caucasian kids and African American kids are now allowed to attend school together. It changed the relationship between the white and the black community for the better. This was the beginning of whites becoming more accepting of blacks. Now we'll cut to Championa with this question. Championa, in your opinion, how has this single case affected the relationship between two different races?
I think that without this case, we would not have given children an opportunity for equal education. Therefore, we have brought two races together by treating them equally. Although there was many that still did not accept this desegregation in schools and did not want it to happen, it changed society for the better.
Well put, Championa. Now I will talk briefly about the interactions of the Brown versus Board of Education case. Oliver Brown, who is a parent of one of the kids denied access to Topeka's white schools, had filed against the Topeka, Kansas School Board, claiming that the racial segregation violated the Constitution's Equal Protection Clause. The federal court then dismissed his case. The interactions of Oliver Brown and the school board brought about interactions of many other people around them. And now we're going to have Championa talk about the moral and ethical implications of the case.
In this case, Chief Justice Earl Warren declared that to separate some children from others of similar age and qualifications solely because of their race generates a feeling of inferiority as to their status in the community that may affect their hearts and minds in a way unlikely ever to be undone. I think he was trying to show that if this desegregation did not happen, we would start to see a change in young people that could affect their attitude towards other kids of other races.
These and other cases that ruled for the integration of the colleges gave encouragement to the civil rights movement and the progress that was soon to occur. Major steps were being accomplished, and this gave the Brown versus Board of Education a chance. The Brown versus Board of Education Supreme Court case was actually 5 separate cases. The Brown versus Board of Education of Topeka, Briggs versus Elliott, David versus Board of Education of Prince Edward County, Boiling versus Sharp, and Gebhardt versus Ethel. While each case was different, the main issue of the constitutionality of the state-sponsored segregation in the public schools. Thurgood Marshall and the NAACP Legal Defense and Education Fund headed these cases. The 3-judge panel at the U.S. District Court ruled in favor of the school boards and the plaintiffs appealed to the U.S. Supreme Court. The 5 cases were consolidated and took the name Brown v. Board of Education and went before the Supreme Court in 1952, with Thurgood personally arguing the case. He raised a variety of legal issues, but the most common was the separate school systems were inherently unequal and violated the Equal Protection Clause, and this made the black children feel inferior to the white children, and thus such a system could not be legally permissible. The court was deeply divided, for some wanted to reverse the Plessis outcome, and others didn't want a change. They were not able to come to a decision by June 1953, so they decided to rehear the case in December 1953. Though Chief Justice Fred Vinson died and was then replaced by Governor Earl Warren of California, and then the case was reheard. Chief Justice Warren was able to bring all the justices to agree and support the unanimous decision declaring that segregation in public schools is, in fact, unconstitutional. On May 14, 1954, he delivered the opinion of the court, stating that we conclude that in the field of public education, the doctrine of separate but equal has no place. Separate education facilities are inherently unequal. The Supreme Court didn't immediately act for the immediate implementation of the ruling, for they expected opposition. They only asked attorney generals of each state with laws permitting segregation to submit plans on how to proceed with the desegregation. More hearings were heard, and finally on May 31, 1955, the justice declared that the plans of desegregation was to proceed with all deliberate speed, and this came to be known as the Brown and Brown II. But it would still be many years before all segregated systems were desegregated.
Stay classy, Omaha.